Good morning, Naledi, and to the viewers. Yes, it is very critical to even go deeper into this judgment to understand what it means, especially with regards to whether the former President Jacob Zuma will have to go back to prison or not. Remember already the time of his sentence, 15 months sentence, already lapsed in October. And the other issue that was brought by, was argued rather by Helen Suzman Foundation, the DA as well as AfriForum, was that the decision that was taken by Arthur Fraser was unlawful, and the fact that they wanted the former President Jacob Zuma to go back and serve the remainder of his sentence. But I am with a legal expert just to take us through in details what it means, because a judge did mention that as paragraph 5 and 6 of the High Court order is being dismissed, then we really need to understand what that means, because it's with regards to the time that the former president had already spent outside prison. But I have a legal expert, Machini Mutlo. Thank you very much for joining us. Just break it down for us. What does this judgment mean?
Look, this judgment is quite clear. One, that the appeal has been dismissed, essentially meaning that the respondents' arguments, particularly pertaining to the unlawfulness of this decision and irrationality of the National Commissioner's decision, has been upheld. It has been reinforced, it's confirmed. But if you take it further, you look into the paragraphs of the court accord, the High Court ruling, which were then set aside, specifically both paragraphs 5 and 6 respectively. What that means is that the paragraph 5 was quite very vivid in terms of what what needed to happen, which was that the former president needed to go back to prison and serve the remainder of his sentence. But what this appeal court judgment means is that this requirement or ruling by the High Court has been set aside. Therefore, the former president is not expected to serve the remainder of his prison term. In essence, it then reaffirms and confirms the arguments by the appellants that by mere effect of serving a sentence or parole, medical being released on medical parole, that on its own is part of serving a sentence, and that has been confirmed. So it means then that the former president is not required by law to return and serve the remainder of his sentence.
Let's look at what it means for the DA, the Helen Suzman Foundation, as well as AfriForum, because as you said, that this judgment in a way is in favor of them in terms of what they were arguing when they said that the decision that was taken by Arthur Fraser was unlawful.
Look, I will just sum it up into this, that it was the respondent came with two-pronged approach. One, to argue regarding the unlawfulness and irrationality of the decision of Arthur Fraser, and that part has been dealt with, it has been confirmed. But the other part was that as a consequence of such irrational and unlawful decision, the former president ought to have served the remainder of his sentence in prison. In essentially, what the respondent argued was that the former president's release on parole was the fruits of a rotten tree. But if you look at it, the former president, it was not out of his wrongdoing, and therefore punishing him for the wrongs of another would not be in the interest of justice. So I think in their view, in Helen Suzman and other respondents' view, this could be a victory, in the sense that it has confirmed the barometers of the powers of the National Commissioner in considering applications for release on medical parole. That part has been confirmed by the position has been confirmed by the SCA, and they wouldn't, in my view, taking it further would not really be in the interest of justice. In my view, the proverbial horse has bolted. That part of Mr. Zuma having to serve the remainder of his sentence is now a moot point. It will just be academic. He has served his sentence, and this a very important part, and this was an argument, raised by the appellant, has been confirmed by the Supreme Court of Appeal.
Well, in a way, the former President Jacob Zuma, as much as they have lost the appeal, do you think is it still a possibility that they could take the matter forward, maybe appeal this case, or it will really not serve a purpose?
Really, I wouldn't even think of any reason whatsoever, legally so, for his legal team to pursue and challenge the SCA's ruling in as far as the decision of Mr. Arthur Fraser is concerned. If they want to challenge that, what would they gain out of it? Because the second challenge to the ruling of the Gauteng High Court was primarily that their client has already served, or he was continuously serving the sentence by virtue of being admitted to being released out on medical parole. So that part has to a large extent been confirmed by the Supreme Court of Appeal ruling. So for any of the parties of the appellants to pursue this on to the higher court, particularly with regards to Mr. Zuma's legal representatives, I don't think it would be prudent of them to do so. Perhaps with regards to the National Commissioner, perhaps it's a route that they may want to take, but as well, I think it's more of asserting the right or the rights of the National Commissioner in as far as the release or consideration of applications that served before the medical advisory parole board is concerned. But even there, one if you look into the papers and the reasons given by the National Commissioner to really grant the application to be released on medical parole, there are a lot of loopholes there. There are a lot of low-hanging fruits, and one cannot but really agree with the Supreme Court of Appeal's ruling in as far as the unlawfulness of this decision is concerned.
So let's talk about who then will take responsibility in a way, because as you said, the Correctional Services was also involved in this. And clearly this judgment by the Supreme Court of Appeal is saying that it was wrong of the former Correctional Services Commissioner to release the former President Jacob Zuma on medical parole. Then what happens in this regard? Who takes the responsibility?
Look, it's really regrettable that we had to be, where we are now, primarily based on some irrational decision taken somewhere. But the reality is that if one loses an appeal, the results, the costs will follow the results. In this instance, the appellants will bear the costs of this appeal, unsuccessful appeal, and that's how far it would go. One didn't pick up any other pronouncements by the Supreme Court of Appeal in terms of consequence management. What has to happen to those who are implicated in having taken decisions of this nature, which in a sense bordered on really the interest of public interest at large, because you would understand that there was a very strong argument that came through from the respondents with regard to equality before the law. Now there would be a perpetuation of some narrative out there in the public that some are more equal than others. If it's the former president is treated differently and he's easily granted, medical parole, to be released on medical parole. So what this in essence means is that, the costs have been, ordered against the appellants. Nothing further was really said about, those who are responsible for having taken such bad decisions in law.
Thank you very much. That is the legal expert, Machini Mutrong, taking us through this judgment, what it means basically for the former President Jacob Zuma, basically summing it up in a way that both the former President Jacob Zuma as well as the Correctional Services will then have to pay the cost of both the DA, the Helen Suzman Foundation, as well as the AfriForum, as this application has been dismissed, but equally so saying that this does not mean that the former President Jacob Zuma will have to go back to prison to serve the remainder of what had left during or at the time when the High Court set aside the decision of the former Correctional Services Commissioner Arthur Fraser. So basically put is that this is in a way a win-win situation for the both sides, as the former President Jacob Zuma will not have to go back to prison, but also it justifies what the respondents on this case, the Helen Suzman Foundation, the AfriForum, as well as the DA, what they've been saying, that the decision that was taken by Arthur Fraser was wrong, that he ignored even the recommendations that were made by the medical advisory board, that former President Jacob Zuma was not eligible for the parole.
Yeah. Makgala Masiteng, the SABC News reporter speaking to us. Thank you so much for that. Let's get more reaction on that story. We now welcome senior legal analyst at the South African Bar Association, Advocate Romeo Ndambeledi, joining us on the line. Advocate, a good morning to you. Thank you so much for joining us. I think first things first, your reaction to the ruling coming out of the Supreme Court of Appeal. Is this the way that you expected the ruling to go?
Yes, absolutely. Thank you very much. Good day to you and the viewers. Look, I've read the judgment of the Pretoria High Court, and I thought that judgment was a correct judgment. And I'm not surprised that the Supreme Court of Appeal has dismissed that application, and they found that there was no merit in that application, and then that the former president was actually completing sentence, being incarcerated and being in prison. So I was not surprised at all.
A win for the former president. I mean, we certainly have had a legal analyst right now saying, well, it is a win-win situation in the sense that the former president does not need to go back and complete that sentence because that sentence has already been served while he was out on medical parole.
It has not been served by him. Also, the judgment of the that sentence must be served, and how? Because you cannot complete the sentence when you're outside. When in terms of the Criminal Procedure Act, you complete the sentence when you are serving it yourself in prison. So let's not forget that here there was an error release, and then the issue of the medical parole that we're actually speaking about was under question and under scrutiny. And we want to hear the directive of the SCA in relation on how that remainder of the sentence must be served. Because remember, the judgment of the Supreme Court of Appeal of Pretoria High Court made it clear that he must serve the remainder of the sentence while he's in prison and is incarcerated.
You see, that's an interesting take, because then I'm keen to hear what the options are then moving forward. If there is the order that the former president must continue serving his sentence inside prison, what are the options then that the court and legal route could be?
Yeah, look, obviously you can appeal to the Constitutional Court, direct appeal to the Constitutional Court, and hear what the Constitutional Court take will be. Knowing how litigious the former president is, I'm sure that this decision is going to be appealed directly to the Constitutional Court, and then the Constitutional Court will have to make a determination. But also, if the matter is taken to the Constitutional Court, the Constitutional Court hardly interferes with the decision of the Supreme Court of Appeal in criminal matters. So it might not actually change the decision and confirm the decision of the Supreme Court of Appeal in this instance, which means that the remainder of the sentence must be served in prison.
Yeah, I mean, that we certainly will be watching those developments closely. The former president challenged the High Court order, not alone, but alongside the Department of Correctional Services. I mean, this ruling by the Supreme Court of Appeal, what does it say to you about the processes within the Department of Correctional Services? Does this put a blight on the department?
Yeah, look, the whole issue of the department and the correctional services system relating to release on parole, obviously has to be actually looked at, because it looked like in high-profile matters there was no equality before the law. So obviously there is a day of reckoning in terms of the correctional services department itself, to look at itself and how its system is being applied in terms of releasing prisoners on parole. So it's very, very much important. It's a bad indictment on the correctional services in terms of how accused are released on parole in high-profile matters. So I think this would, it's another dent on the image of the department relating to parole.
Yeah, and let's sit with the department for a little bit, right? Where when you talk about this blight that this might have on the Department of Correctional Services moving forward, then for the sake of perhaps a constitutionality, what is it, and even legal clarity, what is it that the Department of Correctional Services should do next?
Yeah, look, it's clear the act is there, and then the act, the letter of the law and the act must be followed. This is what was argued before the Supreme Court of Appeal, that there must be equality before the law, and then there must be a proper assessment that is done in terms of the Correctional Services Act relating to the release of offenders. There are people that actually qualify for medical parole that are being denied, and there are people that seem not to qualify to for medical parole that actually get that parole. So there must be consistency in terms of the system of assessing the offenders and how they qualify for parole under the Correctional Services Act. And if that is done and there is equality, I think that will be fair.
Except, and I know that your purview obviously is going to be just the legal argument, except for the fact that we need to consider that right after the arrest of former President Jacob Zuma, we saw quite a bit of instability in this country, and not a little bit. We saw two provinces that were thrust into a massive crisis. Absolutely.
You're quite correct, but even with those kind of unrest, do we want to promote anarchy in the country in terms of equality before the law? Because the law must apply equally to you and me, as equally as it should apply to any former head of state in the country. So the constitution of the Republic applies equally to each and everyone, and I think that is what the Supreme Court of Appeal is emphasizing in saying that things must be done properly, and the letter of the law must be followed, whether the law is being applied to a former president or to an ordinary citizen of the country.
Yeah, I think just one last one that I want to squeeze out of this discussion quickly. What does this ruling by the Supreme Court of Appeal say about the former Correctional Services Commissioner, Fraser?
Yeah, look, in terms of the process and that were done, it shows to you that there was improper procedures that were followed in terms of the release of the former president on parole. So it's very clear in terms of that, because if ever things were done properly, we couldn't be having this judgment. It means that the Supreme Court of Appeal was going to set aside the judgment of the High Court. So it means that the process and the procedures that were required by the Correctional Services Act were not followed to the T.
You talked about how litigious the former president is. Just before I let you go, closing thoughts. Should he go all the way to the Constitutional Court? What are your bets on how he'll do?
Yeah, look, the prospects of success are very low. I've already indicated that when it comes to matters that come from the Supreme Court of Appeal, which are criminal matters, the Constitutional Court hardly interferes with those kind of positions. So I have got no doubt that it will be appealed to the Constitutional Court, and the Constitutional Court will confirm the decision of the Supreme Court of Appeal.